Hi everyone, welcome to today's Current Affairs Daily Notes. Today's topic is Article 371. I'm Ritrisha from GKToday and let us begin. Northeastern states of India have expressed apprehension that having rendered Article 370 irrelevant, the government might unilaterally move to abrogate or modify Article 371. However, the government has clarified that it had no intention of removing Article 371 of the Constitution. So today, we are going to discuss what is Article 371 all about? How is the article applied to different states of India? What is the need for it? So to begin with, there are 11 states at the moment on which Article 371 applies. So what is this Article 371 all about? Article 369 through 392 appeared in Part 21 of the Constitution, which is titled Temporary, Transitional and Special Provisions. Article 371 of the Constitution includes special provisions for 11 states, including 6 states of the Northeast. Article 370 and 371 were part of the Constitution at the time of its commencement on January 26, 1950. However, Articles 371A through 371J were incorporated subsequently. How is the article applied to different states? Article 371 is applied to Maharashtra and Gujarat. Governor has special responsibility to establish separate development boards for Vidarbha, Marathwada, and the rest of Maharashtra, and Saurashtra and Kutch in Gujarat. He has to ensure equitable allocation of funds for developmental expenditure over the said areas and equitable arrangement providing adequate facilities for technical education and vocational training and adequate opportunities for employment under the state government. Similarly, Article 371A, which was introduced by the 13th Amendment Act 1962, applies on Nagaland. Inserted after a 16-point agreement between the Centre and the Naga People's Convention in 1960, which led to the creation of Nagaland in 1963. Parliament cannot legislate in matters of Naga religion or social practices, Naga customary law and procedure, administration of civil and criminal justice, involving decisions according to Naga customary law, and ownership and transfer of land without concurrence of the State Assembly. Article 371B applies to Assam and Article 371C applies to Manipur. 371B was introduced through the 22nd Amendment Act of 1969 and 371C was introduced via 27th Amendment Act of 1971. They both more or less say the same thing, that the President may provide for the constitution and function of a committee of assembly containing members elected from the state's tribal areas, in case of Manipur, from the hill areas. They are to be entrusted special responsibility by the governor to ensure that they can function properly. Similarly, Article 371D is applicable on Andhra Pradesh and Telangana. This was introduced by the 32nd Amendment Act of 1973, which was substituted by the Andhra Pradesh Reorganization Act of 2014. President must ensure equitable opportunities and facilities in public employment and education to the people from different parts of the state. He may require the state government to organize any class or classes of posts in a civil service of or any class or classes of civil posts under the state into different local cadres for different parts of the state. He has similar powers like admissions in educational institutes. Article 371E also applies on Andhra Pradesh. It allows for the establishment of a university in Andhra Pradesh by law of the Parliament, but this is not a special provision in the sense of the others in this part. Article 371F applies to Sikkim. It was introduced by the 36th Amendment Act of 1975. The members of the Legislative Assembly of Sikkim shall elect the representative of Sikkim in the House of the People. To protect the rights and interests of various sections of the population of Sikkim, Parliament may provide for the number of seats in the Assembly, which may be filled only by the candidates from those sections. Article 371G applies to Mizoram and was introduced via the 53rd Amendment Act of 1986. Parliament cannot make laws on religious or social practices of the Mizos, Mizo Customary Law and Procedure, administration of civil and criminal justice, involving decisions according to the Mizoram Customary Law, ownership and transfer of land, etc., unless the Assembly decides so. Similarly, Article 371H applies to Arunachal Pradesh, which was introduced via the 55th Amendment Act of 1986. The governor has a special responsibility with regard to law and order, and he shall, after consulting the Council of Ministers, exercise his individual judgment as to the action to be taken. Then there's Article 371J, which applies to Karnataka and was introduced via the 98th Amendment Act of 2012. There is a provision for a separate development board for the Hyderabad-Karnataka region. There shall be equitable allocation of funds for developmental expenditure over the said region and equitable opportunities and facilities for people of this region in government jobs and education. A proportion of the seats in educational institutions and state government jobs in Hyderabad, Karnataka can be reserved for individuals from that region. And finally, Article 371I, which deals with Goa, but it does not include any provisions that can be deemed as special. So what is the need for this particular article? All these provisions take into account the special circumstances of individual states and lay down a wide range of specific safeguards that are deemed important for these states. In this range of articles from 371 to 371J, Article 371I, which deals with Goa, stands out in the sense that it does not include any provision that can be deemed special. Article 371E similarly deals with Andhra Pradesh and Telangana and does not have anything that can be termed special. That's all for this video. If you want to read more about Article 371, simply follow the link in the description below. And until next time, goodbye and good luck.